so and write on whatever you would like to do. The copy that I have has an original stamp on the front of it, and this is a copy that you will be rendering your verdict on. The law requires that you have heard the charge in its entirety, so I will read it to you at this time. This is cause number 12201-718, the State of Texas versus Brandon Daniel. Charge of the court, ladies and gentlemen of the jury. The defendant, Brandon Daniel, stands charged by indictment with the offense of capital murder, alleged to have been committed in Travis County, Texas, on or about the 6th day of April 2012. To this indictment, the defendant, Brandon Daniel, has pled not guilty. You are instructed that the law applicable to this case is as follows. Paragraph 1. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. A person commits the offense of capital murder when the person murders a peace officer or fireman who is acting in the lawful discharge of an official duty and who the person knows is a peace officer or fireman. Paragraph 2. Individual means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. Peace officer means a person elected, employed, or appointed as a peace officer. Police officers employed by the Austin Police Department are peace officers. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Paragraph 3. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Paragraph 4. Voluntary intoxication does not constitute a defense to the commission of crime. Intoxication means disturbance of mental or physical capacity resulting from the introduction of any substance into the body. Paragraph 5. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Brandon Daniel, on or about the 6th day of April 2012 in the county of Travis, the state of Texas, did then and there intentionally or knowingly cause the death of an individual, namely Jaime Padron, by shooting Jaime Padron with a firearm, and the said Jaime Padron was then and there a peace officer who was acting in the lawful discharge of an official duty, namely responding to a 311 call for service, and the said defendant knew Jaime Padron was a peace officer, you will find the defendant guilty of the offense of capital murder, and so say by your verdict, and proceed to paragraph 7. But if you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of capital murder, and proceed to consider whether the defendant is guilty of the offense of murder as alleged in paragraph 6. Paragraph 6. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Brandon Daniel, on or about the 6th day of April 2012, in the county of Travis and state of Texas, did commit murder by intentionally or knowingly causing the death of an individual, namely Jaime Padron, by shooting the said Jaime Padron with a firearm, then you will find the defendant guilty of murder, and so say by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of murder. Paragraph 7. The state has introduced evidence of extraneous crimes or bad acts other than the one charged in the indictment in this case. The evidence was admitted only for the purpose of assisting you, if it does, for the purpose of showing the defendant's motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, if any. You cannot consider the testimony unless you find or believe beyond a reasonable doubt that the defendant committed these acts, if any, were committed. Paragraph 8. In a criminal case, the law permits a defendant to testify in his own behalf, but he is not compelled to do so, and the same law provides that the fact that a defendant does not testify shall not be considered as a circumstance against him. You will therefore not consider the fact that the defendant did not testify as a circumstance against him, and then you will not, in considering your verdict, allude to, comment on, or in any matter refer to the fact that the defendant has not testified. Paragraph 9. You are further instructed as a part of the law in the case that the indictment against the defendant is not evidence in the case, and that the true and sole use of the indictment is to charge the offense and to inform the defendant of the offense alleged against him. The reading of the indictment to the jury in the statement of the case of the state against the defendant cannot be considered as a fact or circumstance against the defendant in your deliberations. Paragraph 10. In all criminal cases, the burden of proof is on the state. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The fact that a person has been arrested, confined, indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. Paragraph 11. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. However, it is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict not guilty. Paragraph 12. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case or any witness therein, and no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case or any witness therein from any source other than the witness stand. Paragraph 13. In deliberating on this cause, you are not to refer to or discuss any matter or issue not in evidence before you, nor talk about this case to anyone not of your jury. And after the reading of this charge, you shall not separate from each other until you have reached a verdict. Further, you shall not discuss or consider the punishment, if any, which may be assessed against the defendant in the event he is found guilty beyond a reasonable doubt. Paragraph 14. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given you, and be governed thereby. Paragraph 15. A juror may believe any, all, none, or part of any evidence provided by a witness. You are instructed that upon your request to the bailiff, you shall be furnished any exhibits admitted as evidence in this case. Paragraph 16. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during your deliberations. However, you may not share your notes with the other jurors, and you should not permit the other jurors to share their notes with you. You shall not use your notes as authority to persuade your fellow jurors. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the lawyers. Notes are valuable as a stimulant to your memory. On the other hand, you might make an error in observing, and you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of what the evidence was during the trial. Occasionally, during jury deliberations, a dispute arises as to the testimony presented. If this should occur in this case, you shall inform the court and request that portion of disputed testimony be read to you from the official transcript. You shall not rely on your notes to resolve the dispute because, again, those notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict. Paragraph 17. If the jury wishes to communicate with the court, it must do so in writing. Such writing must be signed by the presiding juror and submitted to the court through the bailiff. Paragraph 18. After the reading of the charge and argument of counsel, you will retire and select one of your members as your foreperson. It is his or her duty to preside at your deliberations and to vote with you in arriving at a unanimous verdict. Your verdict must be unanimous, and it must reflect the individual verdict of each individual juror and not a mere acquiescence in the conclusion of the other jurors. After you have arrived at your verdicts, you may use the form attached hereto by having your foreperson complete and sign it in conformance with your verdicts. I will sign and date and time it when I send it into the jury room with you. The next form is the verdict form, which says, we the jury find the defendant Brandon Daniel. There's a blank there for you to insert the verdict that your jury has reached, either guilty or not guilty, of the offense of capital murder as alleged of the indictment. Your presiding juror would sign and date and time that document on your behalf when that verdict is reached, if that verdict is reached. The next form is also a verdict form. We, the jury, found the defendant Brandon Daniel. There's a blank there for you to insert that verdict, either guilty or not guilty, of the offense of murder. Again, your presiding juror would do the same with regards to this verdict form as well. You will be signing only one of the verdict forms when you return your verdict. The attorneys will now argue their viewpoints on the evidence to you. Requested some time in mornings before expirations of certain time periods during the arguments, which I will give them throughout the course of their argument. The state argues first and last because the state carries the burden of proof. Is the state ready with this opening argument?
State's ready, Your Honor.
You may proceed.
May it please the court. Mr. Bishop, defense counsel, ladies and gentlemen of the jury, and the friends and family of Jaime Padron. This is the guilt, innocence part of the trial. This is where we get to bring you evidence concerning whether the defendant committed the offense of murdering an Austin police officer. That's what we're limited to. This is not the punishment stage. This is not the looking for mitigation stage. This is simply, did he do the offense he's charged with? And we're going to talk about a couple of different things. The most important things are the law that the judge has given you, and that's what your charge is all about. And then the evidence presented during the course of the trial. That's all that matters at this stage of the trial. That's all that matters. One of the things we always have to be concerned about as prosecutors, one thing we always have to be concerned about is, did we do a good job in the voir dire of getting people who simply have common sense? Because what our fear always is that no matter how overwhelming the evidence may be, the evidence in this case is fairly overwhelming. All it takes is one person on the jury who just won't believe, that their standard of belief is so high we can never meet that, even though they tell us they're going to hold us to the burden that the court has given us, which is proof beyond a reasonable doubt, which is high, but we reach that all the time. We're comfortable with that. We always fear there's going to be somebody here who's going to say, no matter what quantity or quality of evidence, I'm not going to go along with what these guys are trying to tell me. If we fail in allowing somebody like that on the jury, there's nothing we could say that would be convincing to that person. But if we did what we believe we did, which was get 12 of you who will vote, people who have common sense and who would do like you promised, which is follow the law that the judge has given you and follow the evidence and determine if we've met our burden and the evidence shows the elements of the offense. If we've done that, we're good. As jurors in a case, you're the ones that make the final determination of what that evidence means. You can look at that and you can decide all of the evidence is believable by any witness, some of the evidence is believable, or none of the evidence is believable. For each and every witness, you can pick and choose what you want to believe. Often, the evidence consists of what we call direct evidence or circumstantial evidence, or some combination of it. In this case, we could just rely on eyewitness testimony. Let's say that video wasn't taken. Eyewitness testimony about what went on in that Walmart. And we have eyewitnesses, the two Walmart associates who came in contact with the defendant early on, the Walmart associate who went and called the police and walked into the Walmart with the police. They would have described that to you without a video. And they would have said, this person right over here, who they all identified in court, is the one who ran from the police officer after shoplifting in their store, who the police officer caught, who they heard the gunshot. They didn't see it, but they heard the shot, a bullet went by them. Then they held him down. They had to kick that gun out of his hand. The gun, the witnesses later testified, was the gun that fired the shot that killed Officer Jaime Padron. They would have described his clothes. So all of that would have been direct testimony. One of the ladies there said, I saw him hold the gun up to his neck. and pulled the trigger. And the medical examiner said there was a contact wound from someone holding the gun up to his neck and pulling the trigger. So people sometimes say eyewitness testimony is the least reliable type of testimony. Defense attorneys often say that. But that kind of eyewitness testimony corroborated, you would have found that believable. But we have more than that, because we had the video, which we often don't have. And the video does not show him actually pulling the trigger. But the circumstances of him being found with the gun in his hand right after the trigger was pulled would suggest that he, Brandon Daniel, who was identified by everybody who came in here, is the one who pulled that trigger. So I'm not sure how there could be any dispute about that. But we're going to talk about the charge and the evidence. First of all, in the charge, murder is defined for you, and then capital murder is defined for you. You're told about both of these. And let's be clear, murder is a lesser included offense. Remember during Bordeaux, we talked about that? You only go down to murder if you believe that we have failed to prove the capital murder part of it, if we fail to prove some element of it. Otherwise, you don't need to be concerned about murder, but both are defined there for you in the charge. So let's look at capital murder. Capital murder is when the defendant murders a police officer, and that police officer is acting in the lawful discharge of official duty, and the defendant knew he was a police officer. Now let's go back to how we didn't have to bring you a video. We could have just had witnesses testify that that police officer showed up in a patrol vehicle, fully uniformed with everything on, showing that he's an Austin police officer. And the witness testified, he yelled, "Stop, Austin police officer, I'm a police officer, I'm with APD," something like that, all indicating he was a police officer. But clearly, everyone could recognize him as a police officer. We don't need a defendant saying, "I knew it was a police officer," if all the circumstances clearly show any reasonable person would have known that. But you see on the video, it's clear that he's a police officer. And the defendant's own testimony was, and we're going to talk about that in just a minute, what the defendant said. But even without what he said, the evidence is clear and overwhelming that any reasonable person would have known he was a police officer. And then your charge defines why the police officer part is important. Under our code, it says it has to be a peace officer. But what the judge tells you is that if Jaime Padron was employed by the Austin Police Department as a police officer, then he fits that definition of peace officer. And there's no dispute about that. We had numerous of his co-workers coming in talking about that. His brother talked about him working with the Austin Police Department as a police officer. He was showing up there in his capacity as an Austin police officer because he had been summoned because of either a drunk there or a shoplifter or a drunk shoplifter there. Now, it also defines what we have to prove about his mental state, his actions. And it defines intentionally for you, and it says we have to prove intentionally or knowingly. And intentionally means he had the conscious objective or desire to engage in the conduct. So what conduct are we talking about? We're talking about the conduct of pulling the trigger of the gun. The conduct of pulling the trigger of the gun. Even if you don't have someone saying, even if you don't have a defendant saying, "I intended to pull the trigger of the gun," under the circumstances, you can infer what their intent was by their actions. By their actions. And if his action was to load a clip into a gun, chamber around, take the gun into the store, tell someone ahead of time that, or say to the officers later that I planned ahead of time that if someone confronted me, I was going to use that gun. And then when someone confronted him, sure enough, he used that gun. All that shows what his conscious objective or desire as far as pulling the trigger was. And he says later on, "I saw the officer's face, I shot for his face." But even if you don't have his words, remember the word of the witness, the young lady who said, "I saw him put the gun up to his neck and pull the trigger." It wasn't an accidental shooting. It wasn't a reckless waving around in the air shooting. It was him pointing the gun, him voluntarily pulling the trigger. That's what intentional is about. looking at his conduct. Did he intend to cause the result? Would a reasonable person know that pulling the trigger of a gun that was pointed at someone's face would cause the result that occurred here? What was the result? Officer Jaime Padron was killed with a bullet. So someone pulling the trigger would have to know that that result would occur. Then the other part of that, intentionally or knowingly. We don't have to prove intentionally and knowingly, intentionally or knowingly. Was he aware of the conduct? He certainly was aware that he was firing the gun. Was he reasonably certain to cause the result? Anybody with common sense knows that if you point a gun at someone's head and pull the trigger, it will cause result. Maybe if you found a gun on the street and you didn't know the gun was loaded and you just picked it up and for kicks and grins pointed at somebody's head and the shot went off, you could say, oh my God, I didn't know it was loaded. But remember the thing with this gun. It's a gun he's had for years. It's a gun that he's taken and shot before. It's a gun he purchased hollow point bullets for. It's a gun that on that day, he loaded a clip. First he loaded the clip with bullets, fully loaded, put the clip into the gun, chambered around into the gun, and went to the Walmart with the expectation that someone may confront him when he went shoplifting. So he knew the operation of that gun, he knew that gun was loaded, and he intentionally pulled the trigger on that gun. So the knowing and intentional part is crystal clear. Now here's something that's really important. It doesn't matter that he was intoxicated. Because if a person chooses to take drugs or drink alcohol or some combination of them, their conduct is not excused. You've been told this over and over, the judge is giving it to you now. I don't know what that last witness they called was all about. Because even he wouldn't say that that excused the defendant's conduct. Because it doesn't. If you allowed that to happen, and anybody who wanted to get drunk and commit any kind of crime they wanted to could get away with it. But the law is not that foolish. The law says if you voluntarily, as opposed to somebody slipping something in your drink, and that causes you to do something, if you voluntarily engage in it, whether you're an addict or not an addict, it does not matter. There's no addict exception under the law. The law says if you voluntarily intoxicate yourself, it does not excuse your commission of a crime. Remember, the burden of proof on the state is for each and every element of the offense. It's not an element of the offense that we show the defendant was sober. It's an element that we show what conduct he committed and what law violation occurred. Each and every element. It's not an element of the offense that we show that the defendant shot Jaime Padron in the neck or face or ear or wherever. We have to show that he killed Jaime Padron no matter where he shot him at. If they want to get up and argue, well, the defendant says he shot him in the face, but we all know the bullet went through the neck, and that should make some difference. That makes no difference because that's not an element of the offense. So let's look at the elements of capital murder. We have to show the date that it occurred, and this was established by a lot of different witnesses and also by the video. April 6th of 2012. This occurred in Travis County in the state of Texas. That was shown by several witnesses who were familiar with that Walmart, that he caused the death of Jaime Padron. If you believe that the person in the video and the person who said he caused the death of Jaime Padron, that is Brandon Daniel, did that, then all we're left with on Jaime Padron is proving that he's a peace officer. Remember, he's employed by the Austin Police Department as a police officer, that he was in the lawful discharge of an official duty. Why was he at the Walmart? Because the Walmart people believe there was a shoplifting going on, or they believe there was a drunk in their store or some combination. So the manager called 311 and said, can you send a police officer out? I got this drunk person here. We think he may be planning to drive away. You heard that testimony. You heard the 311 call that was then switched over to 911. So the officer is there in response to that. And when he gets there, he talks to the manager and goes to confront the shoplifter or drunk or whatever it is. So all those elements are easily met. The defense will never get up here and argue to you he was not a peace officer, or that he was not responding to the 311 call, and they're not going to argue that he was not in the official discharge of his duties. That's not going to be disputed to you. That he was shot with a firearm. You're given the definition of firearm. We brought the actual firearm here to you. We had a ballistics firearm expert testify that Jimenez 380 is a gun capable of discharging a projectile. So there's no dispute about it being a firearm. Now here's the real issue on the case. For the defense, this is a real issue. Did Brandon Daniel know that Jaime Padron was a peace officer? Did he know that? And that, if he did not know that, then we have failed to prove by proof beyond reasonable doubt the elements of the offense, and you should find him not guilty of capital murder. If we fail to prove that he knew. So that's what's in dispute. Did Brandon Daniel know that Jaime Padron was a police officer? And here's what a big dispute is. One side says, absolutely, positively, Brandon Daniel knew, Brandon Daniel knew, Brandon Daniel knew because of the uniform, because of the belt that he was wearing. He expected a police officer to show up. He was prepared if a police officer show up. So one side says it's crystal clear, and then there's another side that says, nope, he did not know. How could he have known? He was on Xanax. Even when he said later, it was a confabulation. The odd part about those two sides is that they're both at this table right here. The dispute is right over here. Because no matter what evidence we put on, we can't convince the defense attorneys by proof beyond a reasonable doubt that Brandon Daniel knew. It's clear they don't believe Brandon Daniel knew. Brandon Daniel is convinced that Brandon Daniel knew. And we're going to look at all the different times he kept insisting that he knew, that he knew, that he knew. Even without this evidence, it would be crystal clear that he did know. Because of the officers, what the officer was wearing, the officer's behavior there. But let's look at what Brandon Daniel had to say himself about this. And you saw the interview, we're going to go through some of it. He talked about thinking what time it was, and then I decided to go around on a motorcycle. I decided to shoplift a bunch of items, and on the way out, a cop saw me, and I panicked, and then I pulled my gun out and shot him. He said the cop saw me. And he says, when I walked out, I saw one officer and one plainly clothed loss prevention associate making the distinction. The officer told me to stop, and I knew what he was after. And I had a .380 in my pocket. So I figured that the consequences may be worse, which is an odd thing to say. The consequence of getting stopped in the store with a gun to him was worse than killing a police officer. But he knew who he was dealing with. Then Detective Robinson talked to him, so you're sitting there talking about the officer and the loss prevention guy. He talks about those two eyeballing him. And they knew they were going to confront him. Then he talks about what the officer said. The officer said, will you please step next to me? Will you please follow me? This is what he's saying. The video is available for you to look at. You can hear it clearly. He doesn't express any confusion about it. So the officer says, please come here, please step aside from me over here. And he says, yes ma'am, that's what the officer said. Then she asked him, what did the officer do? Brandon Daniel says, he grabbed me, I turned around, I saw his face, and then I shot him. He doesn't say, no, it wasn't the officer, it was a Walmart security person in a blue jumpsuit. He said, all I saw was one officer who was down, and that one officer who I shot was down. Because Officer Robinson is making it clear that he wasn't getting confused with the loss prevention person. That's why they're asking him this over and over again, to give him a chance to say he didn't know. Talks about feeling bad for the officer. I want y'all to remember this quote from him. He talks about feeling bad for the officer who's doing his job and has kids. And I saw his face. The curious thing in his interview, at this point, no one has told him that this officer has kids. Later on, Detective Robinson confronts him. What do you think about this officer you killed? You know, he has kids. But at this point, no one has said that to him. But he knows this officer has kids. And he doesn't say wife and kids. Isn't that odd? He just says this officer who has kids. Doesn't say a kid or a child. Kids, like at least 2. You'll see how that fits in. Then again, he talks about they're screaming, stop this, it's loss prevention, loss police. He's talking about them yelling out, it's police, it's the police. He says this over and over again. And then he talks about, he turns to red, the officer saying, I'm a cop. All of this is right there in his interview where he's talking now. I think that last expert kind of said you should ignore this. Then later on he said, I didn't say you should ignore this, but you should not ignore this. There's no reason to ignore what the defendant is saying about this issue, about knowing it's a cop or a police officer, whichever one he calls it. We know it means the same thing. Then again, Detective Robinson is talking about people screaming, saying stop, police officer, whatever, and he's saying yeah. You know, he's acknowledging on each of these occasions that we're talking about a police officer. In his words, there's one officer and one plainclothes loss prevention person toward the entrance in front of the McDonald's. As you can see on the video of them walking in. One loss prevention person, one person he says is a police officer. Then he describes the officer. More well-built, white, short, closely cropped black hair. And what was he wearing? And Brandon Daniels says, police uniform. He didn't think he had on a jumpsuit or anything like that. When he was describing him, I asked what was he wearing, he said a police uniform. Then the officer says what color, he says black, which is kind of navy blue is what it is. He says just a normal, and then he says, yes ma'am, had a badge on, no hat, all the normal stuff that you see a cop wear. Yeah, Brandon Daniels said he had the belt with the gun, the handcuffs and things like that, all the normal stuff, yeah. This is what the officer said. He said, stop, and then he said, I'm a cop. And he grabbed my arm and I shot him. He said, stop, I'm a cop. He grabbed my arm and I shot him. And then Detective Robinson says to him, just trying to make sure there wasn't any question about whether he was a police officer or not. And Brandon Daniels says, I knew he was a police officer. Almost everybody can be convinced by this. And so later on, Detective Fugit is talking to him. And he talks about why he had the gun. I had it with me in case there was some altercation. What kind of altercation were you foreseeing? Detective Fugit asked. And Brandon Daniels says, I was foreseeing cops preventing me from leaving the store. So before he went to the store, when he was at home loading his gun, he was foreseeing trouble with the cops. And he talked about wrapping some food up, and he was about to leave. He put him in his backpack and left. And there was an officer and one loss prevention gentleman standing there on the way out. Now, these are not duplicates. These are different times when he's been interviewed by 2 different officers where he's talking over and over again about knowing it's a police officer. He was asked, when you saw the loss prevention officer and the officer, could you differentiate between the 2? Which one was the Walmart employee? He said, yes, sir, I could. Talks about describing what they were wearing. The officer was wearing a police uniform. He says black. But don't let them confuse you by them arguing that it really wasn't black, it was just dark, dark navy blue. It was a police uniform that he was wearing. And he knew it. Then you could ask him, how do you recognize it as being a police uniform? Badge on, and utility belt, gun on it? When did you realize you killed the officer? After I shot him. Point blank in the face. He talks about it as he's walking away. I walked past him. Police officer tried to stop me. I grabbed the gun from my pocket and I shot him. So did Brandon Daniel know that Jaime Padron was a police officer? Sure he did. No doubt about it. What I think is interesting is that, you remember when the defendant is being taken from the Walmart down to the police station by those officers, they can't hear what he's saying, but he's back there talking, and because we cleared up that audio, you were able to hear what he's saying, all the nasty stuff he's saying about, I cap your friend, I blasted one of you. But remember what he says at the end. This is going back to that curious thing he says about feeling bad about him and his kids. Because in the in-car video, before he ever goes in for the interview, this is some of the things that he says toward the end. He asks, are you guys pissed that I capped one of your other friends? You remember he leans forward and asks this? They can't hear him because of the plexiglass, but you can hear him. Right at 3:55:03 in the video. And he says, that's probably it. And he says, well, if there's any consolation, I met him before. Talking about Jaime Padron. And he calls him a dipshit. I said, this dipshit who he's met before, he's glad he's dead. Remember that testimony from Detective Fugit about how 2 days before, at 1 o'clock in the morning, 2 days before the defendant kills Jaime Padron, Jaime Padron and another officer are investigating at the apartment complex where the defendant lives. And they're investigating a vehicle that the door's been left open. That vehicle belongs to Dante, his roommate, and it's parked right outside that apartment complex. Do you think there's any chance that the reason he knows Officer Jaime Padron is that he was there 2 days before and he had some conversation with Jaime Padron? And maybe Jaime Padron mentioned, I'm a divorced man with 2 kids. And the defendant may have thought, well, what a dipshit. And that when he saw him in that store, just ever so briefly, he remembered him. Because, you know, he also knew the officer who was driving the vehicle. Remember how he said a comment about, don't you remember me? And the officer turns out, yeah, I did remember him, but we had a conversation. We talked about Colorado because he's so friendly and personable in that circumstance. So it turns out,
5 minutes.
thank you, Your Honor, the evidence turns out to be that not only did he know it was a Austin police officer that he killed, but he knew which Austin police officer that he killed. 2 days before, the evidence suggests strongly he had contact with Officer Jaime Padron. And when he saw him in the Walmart, he put a bullet into his head. And Xanax doesn't excuse that.
Proceed, Your Honor.
Yeah.
Thank you. Members of the jury, I wish that I could give you, each and every one of you, the person you were before this trial started. I wish you didn't have to see or know what you now know and what you now see. Because you have to do something very difficult today. You have to make a decision. But we didn't pick you, and you weren't selected for this jury because we didn't believe you couldn't do that. You were selected because you promised to make a decision based on the facts and the law of the case. I don't have drama or theatrics. All I have is that, the facts. You may close yourself off and say, you know, it's 1 + 1, and that's 2. An officer is dead, therefore he's guilty of capital murder. It's not that simple. If it was, we wouldn't have bothered with a trial. That's not what trials are for, because the trials are about law and they're about fact. Now, I'm just going to go over this briefly because this is the law. The state must prove every single burden of the charge that they brought against Brandon Daniel beyond a reasonable doubt. Every element. Remember, we talked about reasonable doubt. Reasonable doubt isn't defined by the law or statute. It is what you think reasonable doubt is to you. We talked about that, I think, individually at voir dire, or certainly when the judge talked to you about it. So you define what that is. It's not negotiable. In other words, if you find reasonable doubt and one of your other jurors doesn't, your opinion as to reasonable doubt isn't negotiable. You don't have to give an inch on that. And you should expect that to be respected in that jury room. We talked about that too in voir dire, if you remember. And I put this out there because I want to remind you about that. It's in paragraph 8. You can see it. You can read it. I won't reread it to you, other than to say the fact that Brandon Daniel didn't take the stand cannot be inferred on or deliberated about or even discussed when you're back there making your decision. Okay? Murder is the intentional killing of an individual, knowing killing of an individual. That's murder. That simple definition. Now, capital murder requires an aggravating factor, such in this case, causing the death of a police officer, acting in the lawful discharge of his duties. That is the only part that I'm going to agree about with the state in this time. I'm not going to disagree about Jaime Padron that night acting in his capacity as a police officer and discharging his lawful duty. Wouldn't argue about that. But the accused has to know that that person is a police officer. He has to know. So that we're really left with two questions, right? If we know those are the elements of capital murder, and we know that a man is dead and that man was a peace officer, then we are only left with two questions. What did Brandon intend? And did he know that he shot a peace officer? Let's talk about it step by step. You remember the testimony of Lincoln Lemure? He was one of the gentlemen that held Mr. Daniel down. Do you remember that? And he talked about, saw him enter the store and thought he was drunker than Cooter Brown. That's what got his attention. You remember that? Then he says he called 311 and 911, but did not see Brandon again until Padron got there. Then he walked in with Officer Padron, I guess to point him out. And Archie Jordy was right behind Brandon. You can see in that video, you can see it yourself, right up there at the top. You can see what's going on. He reached for Brandon. Brandon ducked, turned and ran. Now, you can judge for yourself how long he ran or how fast he ran, but you can also see from that video where they started and where they ended up, he ran a pretty good distance. And they ran after him. You see them turn and bolt, and they slow down after the tackle. You can see that. He was tackled from behind and landed face down. He was tackled from behind. Now here's where his testimony gets a little fuzzy. He's adamant that that first shot was the fatal shot. You remember he repeats it over and over. Yes, the fatal shot. Yes, the fatal shot. He keeps saying it over and over again because he's adamant as that's what happened. He says Brandon passes out, woke up and giggled, "I killed a cop." And he said he told this to the detective who was taking his statement. But it's not in his statement. You remember under cross-examination, Mr. Hunt told him, or asked him, where is that in your statement? You had an opportunity to read it, and you had an opportunity to sign it and review it with the officer, but you didn't say that at the time. Now that was a statement that got a lot of emotion, but let me tell you something. Do you think that a detective that's investigating the death of a police officer is going to forget that integral part in a statement? That he's going to forget that that witness told him that? That he's just not going to put it in there? Wouldn't you think that that would be important and that would go a long way to proving their case? That's why Mr. Cobb didn't mention it, because it is inconsistent, because it didn't happen. Nobody else heard that. I'm not sure what the motive for Mr. Lemire's embellishment was. I really don't. And I don't think that he's trying to be dishonest or he's trying to be purposefully wrong. I just think that in the moment and with the emotions, and now that he's reflecting it and he has to relive it again, maybe he believes something now different than what he did then. But here's what they're telling you, is that Lincoln Lemire, who is dead cold sober, he can be inconsistent, and that's okay, and you can remember that. But Brandon Daniel, who was highly intoxicated under Xanax, his words, you got to believe everything. That's okay. One can forget, but one can't. What about Archie Jordy? Well, indisputable, he walked in and saw him drifting from side to side. That's how he got notice of him. He had an empty look on his face, and he appeared to be intoxicated. Thought he might be shoplifting, and he began watching him. You remember that? He even followed him a little bit through the store. And he watched him to put things in his backpack, over his backpack like that, and things are just falling in onto the ground. And he even said, more things are falling out than are going in. And he met, as we said, Officer Padron and Lincoln as they walked in. And he also agrees that he ran and they gave chase. Says he heard a pop and the second shot come between him and Lincoln. But the first shot, we remember, it went through Officer Padron's shirt. It didn't go between them. Now, I'm sure that the state wants you to think he's just shooting wildly out there, shooting at them and shooting at the officer. But that shot goes through his shirt. Because you remember the two ladies, Miss Ramirez and I believe her name was Monica, I can't remember exactly, but they both say confetti flies out of his shirt, like a confetti, and they thought it was a fake gun at the beginning. That's consistent, if you remember, from the items that he had in his pocket. As the bullet passed through, confetti flying out like paper. And we even had that picture where it showed the contents with all the paper. And we know that the second shot killed Officer Padron. That much was established. So the second shot couldn't have been coming between him and Lincoln. Now, I'm not going to blame him for not remembering exactly under a stressful event like that. He just remembers wrong. And as time goes by, it's not any clearer. He says he never heard Brandon say a thing. He sure didn't hear a comment about killing a police officer. But this is interesting. He disarms Brandon himself. He tells you that. He places the gun by that detector, that theft detector that they have that they come in, and you can see there's a picture that was admitted into evidence where the gun was found. And that's about 7 to 8 feet away, according to Officer Kroger, who came in, 7 to 8 feet away. Then he claims that Brandon was reaching for the gun, like trying to continue shooting someone. But we know that that gun was not even within his reach. It was so far away from him he couldn't reach it. And if you look in the video, you can see him take out the gun, place it by that detector, and you see the positions of where the bodies are on the floor. No way he was reaching for anything. He said he kept trying to pull away. But Lemire says he passed out. Now, let's talk about this for a minute. The point of the last expert, the point of talking about Brandon's level of impairment was not to excuse what he did that night, but it was to put into context the statement that he made. So you can see the state of mind when he's in the back of the patrol car and when he's at the police station. You've already heard of the levels of intoxication that he had, the levels of Xanax in his system. We already know how high that was. So he weaves and stumbles throughout Walmart as he walks. You can see that video clear as day. You know that he is impaired. He drops that bag several times. At one point, he even drops them near a couple of children, and one of the children is looking at him with her hands on his hip, like, "What are you doing?" And he's just sitting there picking them up, totally out of it. Then another time, he walks by, a Walmart employee walks by, and he drops his bag there, and the Walmart employee kind of looks at him and says something to him, and he's like, "I'm okay." It's clear that he's intoxicated. He can't quite get everything in the bag. He keeps on missing things, dropping things as he's putting them in the bag. He tries to reach around, as I said before, and place things in his, behind and drops them. Remember when he walks back out to his motorcycle to get his keys? He's walking out to get his keys because he forgot his keys, and he gives the bags to Mr. McCarthy, and he walks out and goes right into a mailbox. That mailbox that's right there, he bumps into the mailbox, goes to his motorcycle, retrieves his keys, and as he's walking back, he bumps into a flagpole, or maybe he bumps into the flagpole before he gets his keys, I'm not sure which. But he bumps into a flagpole. The other employees that were sitting there taking a smoke break all kind of say something to him, and he waves at him, turns around and walks right into the building. I mean, they notice how drunk he is. In fact, several of them told you we're out there talking about how intoxicated he was. Look at his facial expressions on the back of that car. I mean, it's easy to sit there and say, oh, we're just going to focus like the state wants you to do and focus on all the things that he said back there, all those negative things he said back there. It's easy to focus on that, but if you look at his face, it's clear to see that he's impaired. He's pressing his face against the plexiglass, talking thick and slurred. Even Christopher Lester with EMS says he had a blank, cold effect with no emotions. Look at State's Exhibit 7. His pupils are the size of saucers. That's a clear indication of impairment. I said that already. Speech was thick and slow. Remember Officer Arevalo? He testified, he rode in the car with Officer Knopp back to the police station. And he tells you it was obvious he was on something. And he's a drug recognition expert. And he was certified at the time in drug recognition. He knew it. He even said it. He said it in his report and mentioned it then. Officer Knopp clearly appeared to be on some kind of a depressant. He even knew what he thought he might be on, a depressant. Now, we mention all that because what he says in his statement is important. He describes the incident every single time as happening while it's standing up. Every single time. You were standing. Yes, I was standing. He describes a distance that is greater than arm's length. He says, that about right? That's about right. That's about the perfect distance. Grabbed me, I turned around and shot him. It's kind of a jumble. I just turned around and shot. Is he describing what's on the video? Is he describing what really happened? Because we know that that is absolutely inconsistent with what happened on the video. We know that he didn't shoot Officer Padron standing up. We know that it happened on the ground. Insists he only fired once. Doesn't remember firing another time. He insists he only fired once. Every time he's asked that question. He's not sure who tackled him, he says. At one point he says, the police officer. At another point he says, loss prevention tackled me. He's not even sure about the number of people who tackled him. At one point he says 2, another point he says 3. He can't remember exactly how it happened. And he describes 3 or 4 voices behind him screaming. But they want to tell you, no, there's no way, despite the physical evidence or medical evidence that's presented to you, there's no way that in any way, shape, or form that he was intoxicated or impaired, so he doesn't remember because he has perfect recall of the event. He doesn't have perfect recall of the event. Just look about the things that he describes in his video. You can talk about his speech and what he's talking about. When he's describing the event, he is not describing the events that we all saw on video. He's describing something else. He consistently claims that the event happened at the McDonald's, that everything from the minute that he made contact with Officer Padron and the loss prevention people, everything happened within that 4-foot frame, right there at the beginning of McDonald's. Describes the loss prevention officer in a blue jumpsuit. Where's the blue jumpsuit? There's nobody in a blue jumpsuit. Nobody testified that loss prevention people at Walmart wear a blue jumpsuit. And he says he was tackled after he shot Officer Padron. He says that clearly. And again, he says initially the loss prevention tackled him. He can't recall when he cocked the gun. You remember that Detective Robinson had to tell him, now Brandon, you told me, remember Detective Fugit wasn't here, you told me that you cocked it at Walmart. Because he had just got finished telling Detective Fugit that he cocked it at home. My memory is fuzzy. 50-50 on either side is what he says. Now he says he took 4 bars of Xanax. That's what he says he took. But Fugit found a text message where he arranged to purchase 10 Xanax. He said, hey bro, make that 10 instead of 8. And they found 1 single tablet of Xanax at his house. Circumstantially, that suggests he took at least 9, possibly 7 if he only got the 8. And surely the levels of Xanax or Prazolam in his system bear that out. 0.16 milligrams. Remember that therapeutic amounts of Xanax or Prazolam are distributed in nanograms. That's how much he had. Look at the things he says. You know, he's trying to remember. Xanax makes you lose your memory badly. He remembers bits and pieces. It's very intense and hard to think. He started using Xanax 4 months prior, so we know he built up an immunity, but we know that level, so he could still function or he could still appear to go walk around. He wasn't falling asleep like Dr. Masters told you he might have been if somebody who didn't have any kind of experience with it or usage of it. And he describes being in the grips of this addiction, going broke, spending money on drugs, having a good job at going broke, and in a downward spiral. He says that in his statement. He loses about 5 hours of time. He thinks it's 11 and it's 4 a.m. in the morning. Let's talk about this text message to Jenna. Now, I'm not sure where the state was going with that. I mean, surely they had some ridiculous kind of explanation as though this text was meant that he was going out to do something that was going to make, you know, Jenna remember him for some infamous act. That's what they were trying to suggest. I think that's so ridiculous it doesn't even really warrant consideration. It's the same kind of ridiculous statement as when the state asked Mr. Glasgow, so he was trying to draw attention, purposely trying to draw attention to himself, when it was clear that he was just intoxicated. Mr. Glasgow wouldn't even admit that. He said, well, I don't know if he was purposefully. Like if somehow he was trying to draw somebody there or trying to draw an officer so he could shoot. That was maybe that was just my inference, but I certainly remember that testimony. And so now they come up with this explanation about this text message. Well, we know that it was sent about 1:30 before the incident. And this is it. All I know is that 100 years, he meant years, but he wrote yes. From now, all you remember, you and my dreams, and that will be enough. Just dreams. Life is pain. He misspells pain. Jenna told you, I thought that was meant for me and our relationship, that all we have together from then on is dreams, but it was so jumbled it worried me. And so she calls him. She even calls him in the morning, but of course, he's already in police custody. And she's already told you, since we broke up, he was in a deep depression, sadder than I'd seen him. So that leads us to this question. What did Brandon intend? You have to take that in pieces. There's no other way that you can take it but in pieces. What do I mean by that? What I mean is, what was his intent when he was first approached by Jaime Padron? What was his intent? Did he take out his gun and shoot Jaime Padron? No. He ran. He ran away. He ducked under his arm and ran away to escape. That's what he intended to do. His intent was to escape, to leave. It wasn't until he was tackled that the gun came out of his pocket. That's what we know his intent was. Now, the prosecutor is going to tell you that that intent can be formed in an instant, because they can't get around the fact that he turned and ran and tried to get out that store. So they have to tell you that. But that leads us, if it can be formed in an instant, to what did he know? What did he actually know? Well, he knew there were at least 2 loss prevention officers and 1 police officer behind him. That much we knew, attempting to stop him. Remember, he turns around. He heard them run after him. He was tackled from behind. He didn't see who tackled him. He was tackled directly from behind, fell flat on his face. He's not even sure who tackled him. He's not even sure who's tackled him. So the state says, well, you know, you can believe all of his statement, but not those parts that are inconsistent with our story. You can't believe those parts. He was turned around and immediately shot. We know that went that fast. That whole incident happens so fast. In the briefest of seconds it happens. He's tackled. Someone's on his back. He doesn't know who. He turns him over and shoots whoever turns him over. All he sees is a face. He didn't know who he shot. How could he? He certainly didn't know the person he shot was a police officer. Now they're going to say, well, what about all those statements he made about, no, I shot a cop and I still shot. Let me tell you something. He's on the ground, and by the time they pull him up, or maybe even while he's lying on the ground, he passes out, wakes up, and sees the person he shot and recognizes that the person he shot was a police officer. But certainly when they picked him up, he knew. When they had him in handcuffs and all the other cops were around, he knew. When dozens upon dozens of police officers show up, so it's not reasonable to assume that somebody says, man, I can't believe he shot Jaime, or he shot an officer, or the officer has 2 kids. Because Mr. Cobb wants to tell you, oh, he met Officer Padron 4 days earlier, or 2 days earlier, and the only thing you have is him responding to a call about a suspicious vehicle, where he closes the door, is what the report said. He closed the door to the car and left. Doesn't write that he makes any contact with a single individual. Incidentally, that car wasn't even his, it was his roommate's. And he wants you to say that Officer Padron saw him out there at 1 o'clock in the morning and had a personal conversation and volunteered to Brandon Daniel, oh, by the way, I'm divorced and I have 2 kids? That he just volunteered that to a guy he's investigating at 1 o'clock in the morning 2 days before? Who does that? What officer is going to share personal details with the person that they're investigating about their life? Or is it more reasonable to assume that he's there and he's in cuffs and they're searching him and they're trying to get him out of there, and some of these officers says, well, then he has 2 kids. That's reasonable. That's how he heard. That's a lot more believable than the stretch that they want you to make. Look, I'm not going to sit here and ask you to walk Brandon Daniel out of this courthouse. I'm not going to sit here and ask you to absolve him for what he did that night. He committed a crime, and he should pay for that crime. Paragraph 6 tells you what that crime is. Committed the crime of murder. he intentionally and knowingly killed another individual. That's not absolving him of anything. That's making him take responsibility for what he did that night. But what they haven't proved to you, and what they can't prove to you beyond a reasonable doubt, is that this was capital murder. They cannot. That video is powerful, and not only because a police officer dies, because you can see from the moment he's chased what his intent was. And you can see the incident happen in the briefest of seconds. Ladies and gentlemen of the jury, you're not here to do the popular thing, but you are here to do the right thing. And if you follow the law and the facts and render a true verdict, you will find Daniel guilty of something. Murder, not capital murder. They have not proven their case beyond a reasonable doubt.
May it please the court. Ladies and gentlemen, what Mr. Urrutia says to you is not evidence. You can't make an inference that someone told him Jaime Padron was a police officer after that shot was fired, because no one sat here and said that was ever said. Not one witness sat here and told you that. He has to tell you that because he has to make some argument to try to appease you to wonder why we're here. He tried to tell you we're here because there's facts in dispute. We're here because in a case where the state seeks the death penalty, it must be tried before a jury. We have to present it to you, not because we have any doubt, not because there is any doubt, not because any doubt exists, because we have to. If you listen to the evidence, you listen to the witnesses. What they told you, there is no dispute in this case. He put up a lot of words of Lincoln Lemaire, of Archie Jordy, the ones he wants you to focus on, but the ones that he didn't put up there were the fact that both of those men testified. I'm a cop. I need to talk to you. Why would he leave that one statement out of that? Because it's inconsistent with his closing argument. He doesn't want you to believe what everyone in this courtroom except Mr. Urrutia believes. That man right there knew Jaime Padron was a police officer. As Mr. Cobb pointed out, he said it again and again and again. They tried to call him on it, give him an out. Give him the argument Mr. Urrutia made to you. Well, how can you be sure it was an officer? Well, I saw his badge, I saw his gun, I saw his handcuffs. There is no doubt. Do not let the fact that you're here create doubt in your minds, because it doesn't exist. It's hard. People think they're arguing this before us, there must be some dispute, there must be some element I'm missing. It can't be this easy. It is. In this case, it is. You are a jury that has a capital murder on video. Don't make it harder than a capital murder on video. When he describes the events to Detective Fugit, you have the interview, you can go back and you can watch what you want to watch. But right after he does the sketch for Detective Fugit, actually the very closing part of doing the sketch, about feet-wise, how far was that? Brandon Daniel, 7 feet. Detective Fugit, okay. And were they standing in one position or were they moving? Brandon Daniel, standing, okay. One position. And where were they looking? Out towards the store, pretending not to look at me, Detective Fugit. And so what did you do at that point? At that point, I proceeded to walk right next to them on the way out. Detective Fugit, okay, can you draw a line as to how you walk towards the exit door? Brandon Daniel. If I was right here, I started exiting this way. And you see on the diagram, he draws that third circle with the arrows. That's him walking past Officer Padron. From here, he grabbed me. Detective Fugit, who grabbed you? Brandon Daniel, the police officer. How did he grab you? He grabbed me and he said, "Would you come with me real quick?" And I said, "Why?" And then I started running. Detective Fugit. "Okay," and he grabbed you on the right arm. Brandon Daniel, left arm. As I was, "Your left arm?" "Yes." "Okay." And then he tackled me. I pulled the gun out and I shot him. Now, how did you pull the gun out prior? Now, did you pull the gun out prior to him tackling you? Or, no, it was kind of at the same time. He grabbed me and I was running. I pulled it out. So you pulled the gun out as you were running? Yeah. He is very clear in his statement to Detective Fugit that he knew Officer Padron was chasing him. He knew Officer Padron tackled him. And as he's running, he took that gun out, he landed on the ground, and he fired 3 shots. It doesn't matter which one was first. It certainly doesn't matter which one Lincoln Lemaire thinks was first. The order of the shots is irrelevant. The only relevant factor for you to consider is, did one of the shots fired by that man kill Jaime Padron? That's it. It doesn't matter if there were 1, if there were 2, if there were 3. If he fired the shot that caused Officer Padron's death, that's the issue before you. Mr. Urrutia stands up and he says, well, what was his intent? It was to escape. It was to shoplift. And then he says, well, he's clearly guilty of murder. He wants to throw that in there as noise. He said the prosecutor's going to stand up and argue intent can be formed in an instant. And he has to tell you that because it only matches these facts. I have to tell you that because that's the law. Intent does not require premeditation. Intent does not require a plan. Intent does not require a motive. Intent is formed when you have a handgun and you pull the trigger. The only way it's not intentional is if it's an accidental discharge. There is not one witness in this case who indicated anything consistent with an accident. That's what intentionally means. Don't lose sight of the forest for the trees. It doesn't matter if he thought, if I get out of the store, I won't have to shoot him. What matters is when he put the gun to Officer Padron's neck and pulled the trigger, was it intentionally or was it an accident? And there is no evidence before you that it was an accident. Make no mistake, he intentionally killed that officer. You're told in the charge, voluntary intoxication is not a defense to a crime. How many times did Mr. Urrutia mention to you voluntary intoxication? Again and again and again and again. It's not a factor. It's noise. He wants you to focus on Xanax because it's a lot more pleasant to his client's fate than focusing on the fact that he killed a police officer. You can't say he was so intoxicated he could not have formed that intent because the law doesn't allow that. You do something intentionally or knowingly, it doesn't matter how drunk you are, how high you are, how jacked up on whatever it is you are, you're guilty. There is no evidence before you that he didn't know that he shot an Austin police officer. You have to make your decision based on what you heard here, out of that chair, what you saw on that screen. And every witness told you he identified himself as an Austin police officer. Every witness told you he was wearing his full uniform. He told you he knew it was a cop. From the very moment it happened, he told Lincoln Lemaire, I killed a cop. And he wants you to disregard this as some sort of fantasy of Lincoln Lemaire, and obviously he would have told the officers that at the station. But is that really something you're going to consider to ignore? This is a man who just witnessed someone get executed within 2 feet of him. His recollection may be a bit off. He may have left out little details. But that statement, I killed a cop, is consistent. He says it in the back of the car. He says it in the walk from the car to the interview room. He says it in the interview room. It's amazing that Lincoln Lemaire made up the one fact that he says again and again and again and again, and you're supposed to disregard it now because he says it so many times it can't be true. That's the ridiculousness of their argument. Everyone here knows what happened. On April 6, 2012, that man in Travis County, Texas, shot Jaime Padron and killed him. He did it intentionally. He did it knowing he was a police officer and the officer was performing his duties. That is capital murder. It is that simple. You've seen it. Everyone described it for you, and we expect you to find him guilty of that offense. Thank you.
Jim? Ladies and gentlemen of the jury, I am going to now instruct you to retire to the jury room. We'll be sending portions of the evidence in with you. You can request anything that was admitted if you need to see it at this juncture. You may retire to the jury room.